Next slide. Next. So the agenda for today is, of course, I am the host for the session today. My name is Dr. Mugdha Lele, and I'm representing the Venture Center team here. I'll give you a brief overview of the ANRF Plus Venture Center Outreach Initiative, introduce the speakers, and then hand over the session to the speakers for today. Next slide. So briefly about Venture Center, just to set the context, we are a ecosystem which supports startups right from the ideation stage all the way till they can commercialize their products. And when I say startups, we also support innovators, researchers, academicians to take their innovations ahead. Broadly, the ecosystem that we have in existence is mentoring, funding, a lot of infra facilities. There is also a very good information database, which is the funding database available. And we have plug and play labs, prototyping, testing, analytical, regulatory labs, and very importantly, tech transfer facilities and IP filing services, which are available on campus here with us. Next. We have been in existence for the last 20 years now, worked with 1,000+ startup and innovator teams. Spin-off companies is one more specialization which Venture Center specializes, and we can handhold academicians and researchers to form their own companies and help also put policies in place for the academic institutions. Next slide. The TechX.in vertical at Venture Center, which is co-hosting this event here today, is a technology transfer hub at Venture Center. The focus is on facilitating win-win technology commercialization partnerships. Next slide. How do we do that? We have three important offerings: technology commercialization, which involves tech marketing, deal structuring, agreements, valuations, negotiations, also spin-off creation and new venture creations. We also help institutions put in the policies in place, filing intellectual property, and support academia to take ahead their innovations to the market. The third important vertical is industry-academia partnerships, which we do along with industry partners and academic partners. The ANRF Plus initiative at Venture Center is a collaboration between ANRF and Venture Center as an outreach initiative. The scope of this initiative is on intellectual property, patents, technology transfer licensing, and broadly innovation management. The kind of activities which we handhold is online help desk, mentoring clinics. Sign-up links for both these initiatives will be available during the session on the chat box. We encourage all of you to sign up for the mentoring clinics, which are specifically put in place for helping innovators take their ideas ahead and filing patents for their innovative ideas. There is also access to webinars. The link for that also will be put in the chat box. In addition to that are these live webinars which are happening around once or twice in 2 months, one webinar. These are free webinars which are available for anyone to come and attend. Next. We can go to the next slide. Let me now quickly introduce the speakers. We have two speakers. There is a lead talk which my colleague Archana will be handling. But first and foremost, let me introduce you to the key speaker, Dr. Premnath. His background is in chemical engineering. He is a bachelor's from IIT Mumbai with a PhD from MIT in the US. He has also been a Chevening Technology Enterprise Scholar in Cambridge in the UK. Earlier, he also headed the IP group at CSIR NCL. But his key role is in setting up here the Venture Center and most importantly, the IP Facilitation Center and the TechX.in, that is the Technology Transfer Hub at Venture Center. Dr. Premnath himself is a technology developer with 2 of his medical implants already in the market, and he has provided leadership for teams which has gone ahead and won a lot of national awards, the teams for Venture Center and other startup teams also. The second speaker for today is my colleague Archana Joshi. She works with the IP and tech transfer teams here at Venture Center. Archana has a background in organic chemistry. She has been with Venture Center for more than 15 years now. In addition to her organic chemistry background, she has also done a PhD diploma in patent laws from Nalsar University. She herself is a registered patent and trademark agent with the Indian Patent Office. She is also trained in technology transfer and commercialization with 57 RTTP credits to her resume. With over 12 to 15 years of experience in IPR, handling patents across different domains. Her expertise is in patent drafting, filing, prosecution, prior art searches, technology assessments, IP strategy, and also mentoring startups. So none other than Archana to handle today's session on IP, how to file your intellectual property. With this brief introduction, let me hand over the session to Dr. Premnath first, and then Archana will take over. Please ensure this is do not disclose any confidential matters during the Ask Me Anything session. Also requesting all of you to be on mute, and we will be taking your questions in the chat box, and Dr. Premnath will be moderating the Ask Me Anything session. Over to you, Dr. Premnath.
Thank you, Mukta. Can you hear me clearly?
Yes, we can hear you.
Okay, good. So today's topic is largely about it's a do-it-yourself primer on patents, which Archana will be talking about. But I noticed in the registration forms that there were several questions which were related to patents of a more generic nature, and I thought I will take this up right in the beginning so that everybody is in the right frame of mind, right? So to start with, today's session is focused on patents, and the patents are just one type of formal intellectual property rights provided by the government, right? I wanted to first just share a few points and perspectives on just this about patenting as a system, and also why, as academics or as innovators, entrepreneurs, you may wish to consider patenting and why you should do that. Because there were some questions about some of these things which I think are very fundamental and people need to understand that first. The origins of the patent system, okay, come from a time when kings wanted to interest and entice innovators to operate from their own jurisdictions. So European kings wanting to bring inventors to their cities and towns so that people could benefit from the innovation that people were coming up with, right? And to benefit from, the local population could benefit from use of those inventions. And the kings promised in return a right, which basically said that there will be a period of exclusivity that we will allow you when other people, you can prevent others from necessarily practicing the same thing. Okay. In return, you have to come here, practice it, and you also need to disclose what you're doing, right? And that is what was the fundamental principle behind the patenting system. So there are three important points here. One, that this was a mechanism to incentivize inventors. It was not something to restrict inventors in any way. It was a measure to attract and incentivize inventors. Number two, it was a measure, it was a deal between the government and the inventor by which one decided that the government would provide a fixed period of time where there will be an incentive to the inventor or the owner of the patent, so to say. And in return, the inventor would disclose their invention, and number three, practice it in the region where the rights are being provided. Notice one more thing, that these are regional rights, right? These are provided by a sovereign or a government, a local government, and these are rights which are provided to inventors to incentivize them. So that was the basis on which this was all done. Over the years, one has noticed that thanks to this, we have a large body of open literature of patents where a lot of inventions have been disclosed, and every government is obligated to make it public, and therefore it is available to everybody to read, including you and me, even though the invention might have happened in, say, Russia, right? So we can actually see those inventions, and the intention is that this public disclosure of inventions accelerates the pace of innovation over a period of time, right? And is in the broader interest of society, right? So that's one of the fundamental premises behind the patenting system, which one should keep in mind. One other point I want to just quickly bring about before I leave the floor for Archana is why should academics, researchers, and individual inventors, spend their time in patents, right? And that's something which I wanted to address as well. One has to understand that a patent provides a right which basically allows the inventor and the owners to exclude others from practicing that particular invention for, say, a period of 20 years. Now, this is a protection for anybody who is going to, say, invest their life's efforts and money into that particular idea. And when that happens, they would like to have, the people who are putting in those resources would like to have some protections for their resources that they're putting in, right? They would want the people who are going to execute on those ideas to have an edge of some kind. And that edge is what is provided, that sustainable edge is what is provided by a patent. There are also other benefits. If, let's say, you have an idea and you keep it in your mind, you are essentially, if say something happens to you and a car hits you, that idea is gone with you. Okay. But whereas something which is documented is something which is available to society as a whole. But not only that, it is also, you can trade with it, right? It becomes an asset that can be traded. Yet another important aspect I want to tell you about is that please realize that in the past, largely people were having physical assets, right? Uh, and those physical assets were of the nature of land, property, and so on and so forth, land, buildings, a car, and whatever it is. Here is an opportunity for people who are knowledge workers to create property and assets which can trade just like those properties. And especially those people who, are not necessarily already endowed with a lot of physical property have this great opportunity to build intellectual property, right? And for academics, one of the top reasons you need to do this is to ensure that there are people who are interested in investing in your ideas, right? To attract them to your ideas. And that is a very important motivation for many of the academics and researchers and ANRF grantees to consider patenting so that they can attract people to those ideas which will be needed. Those resources and those people will be very important to translating those ideas to market. Okay, with that, I will stop here. I'll request Archana to share her slides and begin her talk. I'll come back after the talk to discuss and address some of your questions at a later stage. Okay, so Archana, you can unmute yourself, right?
Hello.
Yeah, we just need to ensure, yeah, we can see your slides. Please, there are some boxes appearing which you need to get rid of.
Yes, sir.
Yeah, please go ahead.
Okay, thank you. Good afternoon. Good afternoon, everybody. So let us start the session on do-it-yourself primer on patents. So Sure. So the objectives of today's session are to understand what the inventions are, the essentials of patent law and procedures, then anatomy of the patent specification, how to draft a simple patent application, and step-by-step guide of the patent prosecution in India. Now, we all know that the patents are granted to the inventions. So what exactly the invention means? The invention is a product or process that provides a new way of doing something or offers a new technical solution to a problem that surpasses the trivial solutions. So there is a difference between invention versus idea. So idea basically is a thought and concept. It may identify or propose a solution, but do not provide or not necessarily provide the technical solution to the problem.
For example, if I have an idea which states that I wish there was a pen that could translate the languages. But the invention, when I invent something, the invention speaks about how it will happen. Like, for example, a pen containing a microphone, processor, translation software, display, and speaker that translates spoken words in real time. Another example is, suppose if I want to reduce the water wastage in agriculture, how would I do that with the help of invention? Like an automated irrigation system comprising soil moisture sensors, wireless controller, predictive irrigation software, and electronically actuated valves that irrigates only when soil moisture falls below a defined threshold level. So this is a difference between idea and invention. Basically, the idea tells you what you want to achieve, and the invention tells you how you will achieve that particular thing. Okay. So next is there are some nomenclatures which have been used in the patent system. Invention, which refers to the novel solution to a problem. Novelty standards are global and not the local, because when we have to satisfy, or when we have to determine the novelty of a particular invention, we have to check the prior arts published all over the world and not only in a specific territory. Thus, the novelty standards we have to set. The novelty standards we have to set with respect to the global standards and not only for the local. Then technical invention, technical solution to a problem. Technical inventions that qualify for a patent once they satisfy the patentability criteria. So patentability criteria are different from each country or for each region. And patents are enforceable only in that particular region which issued that particular patent. When the patent is granted by the patent office of that particular country, then only you can enforce the patent rights in that territory. Patents are territorial in nature. All the IPs, trademarks, copyrights, design, so all these intellectual properties are territorial in nature. That means you have to file separately in different countries in order to enforce your rights. As per our Indian Patent Act, Section 21J talks about the definition of invention as a new product or process involving an inventive step and capable of industrial application. So the definition of novelty is not defined by the Act very clearly. However, we can say that anything that is new, unknown, not published, undisclosed, not in public domain, not discussed, not used or sold anywhere in the world before the filing date of the patent application, then it is called as a novel invention. Then inventive step, in some countries or in some jurisdiction, it is also referred to as non-obviousness, but the meaning is same. The scope of both the terminologies is same. So as per the definition provided by our Act, the inventive step means it involves the technical advancement as compared to existing knowledge or having economic significance or both, which makes the invention not obvious to the person skilled in that particular domain. Industrial application, it is capable of being made or used in any kind of industry. So these three are basic criteria for the invention to be satisfied if you want to file a patent. Then what can be an invention? The medical device that reduces surgery time, a new pharmaceutical compound composition, manufacturing processes or methods, an improved agricultural machine, formulations, machine or apparatus, or improvements in any of the above we can call them as inventions. So what is not an invention? As per section 3 and 4 of our Indian Patent Act, they define or they mention a list of inventions which are considered as not patentable invention, even though they satisfy the novelty and inventive step criteria. So there is a huge list provided by our Act. So I have not mentioned all of them over here, but few of them over here for your reference. Some inventions which are contrary to the public order or morality, which causes the serious prejudice to human, animal or plant life. So those inventions are not at all patentable. Discoveries of any living things or non-living substances occurring in nature, not patentable. Substances obtained by mere admixture, not patentable. Plants and animals in whole or any part of them, other than genetically modified microorganisms. So genetically modified microorganisms are patentable, but the new varieties of plants are not patentable However, you can protect the new plant varieties and the Plant Varieties Protection and Farmers' Right Act. Method of agriculture or horticulture, then processes for medicinal, surgical, curative, diagnostic, therapeutic or other treatment of human beings and animals. So these type of inventions are not patentable. However, you can file a patent for the inventions related to medical devices. Mathematical or business methods or algorithms per se are not patentable. Inventions related to atomic energy and literary, dramatic, musical, artistic work, presentation of information. So these type of inventions are not patentable. When we heard the word patentability, what does that mean? The patentability, in simple word, can I get a patent for my invention? Okay, so how will you check the patentability of your invention? Your invention must satisfy the novelty, inventive step, industrial applicability or utility criteria, and in addition to that, it should satisfy the patentable subject matter as per the statutory requirements these statutory requirements differ from country to country based on their patent laws. So these four things should be satisfied by your invention to be eligible for the patentability. Patentability will be determined based on the prior art. So the definition of prior art is clearly not available as per our Indian Patent Act. However, Patent Act defines the new invention in section 21L. Any invention which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of the patent application. So that means any type of information that is available to the public before the filing date of your patent application is considered as prior art for your invention. So any publication, for example, the patents, technical publication, conference papers, marketing brochures, products, devices, equipments, even newspaper articles as well. So these things are considered as prior arts if they are published before the filing date of your patent application. Now, how will you check the novelty with respect to the prior art document? So your invention, as you can see on your left hand side, you have come up with some invention. If the prior art document, you can find out one prior art document which is very relevant to your invention and which is very close to your invention. Then you can just compare the features involved therein, features mentioned in the prior art and features of your invention. Then if your invention in light of that prior art is entirely new, then you don't need to subtract anything from your invention. You can just check the patentability as per the statutory requirement and inventive step, utility, etc. and go for filing a patent. But if the prior art, the relevant prior art and your invention with respect to that is partially new or the entirely old, in that case you have to subtract something. So the subtractive rule you can apply over here and you can ask where does the key point of invention lie, so that it will give you the idea to do the research and development, research in this field more so as to satisfy the novelty criteria. Now next is inventive step. Inventive step I have illustrated with respect to one example. If the product X comprising A plus B plus C, these are the reactants and the product is X. The closest prior art talks about the reactants A plus B. And the problem that I found out is the technical problem, how to improve the product X. In order to improve the product X, I have added into it the distinguishing feature, that is C, the reactant C. If I have added to the product in order to improve the product, the technical effect of the C was unknown. In that case, I have come up with the inventive solution. Now, if the technical effect of the C was known from the prior art too, then my invention is not considered as having any inventive step. It is considered as having very obvious solution. Please note that while determining the inventive step, examiner at the patent offices will refer to the multiple prior arts. They will not rely only on the one prior art. They will refer multiple prior arts, and based on the teachings of those prior art, if your invention is obvious for a person skilled in art, then they will come up with a result that your invention doesn't have any inventive step. But while determining the novelty, examiner will refer only to one prior art at a time. Now, industrial applicability, most of the inventions satisfy this industrial applicability criteria, but if you look at these pictures, so they don't have any useful purpose and they don't include any operative names. So these type of inventions, since they don't have any industrial applicability, they are not patented. Now, how will you check the prior art and how will you do the prior art searches? So there are free databases as well as paid databases. So free databases, when the inventor comes with a new invention, it is always advisable to do the prior art search based on these free databases. Google Patents, then WIPO Patent Scope, eSpaceNet, that is European Patent Office database. We also have Indian Patent Office database in pass for doing the prior art search at our Indian Patent Office database, and then USPTO. So these free databases are there. You can put relevant keywords of your invention, and then number of patents will retrieve. Please go and check what exactly the invention disclosed in those patents and find out the closest prior art of your invention. Now, once you are very sure that your invention is patentable, your invention has novelty, inventive step, industrial applicability, and it is not falling under the exclusivity criteria as per the section 3 and 4 of our Indian Patent Act. Then, then you decided to file a patent. Now, who can file a patent? The section 6 of our Patent Act talks about who can exactly who will be the applicant for the patent. You can either alone or jointly, any person claiming to be the true and first inventor, then assignee or the applicant of the person claiming to be the true and first inventor, or the legal representative of the deceased person who immediately before his death was entitled to make the application. There are 4 patent offices in India: Kolkata, Mumbai, Chennai and Delhi, based on the jurisdiction, appropriate jurisdiction. How will you decide the appropriate jurisdiction? Where your invention, you have created your invention, or where your place of business is situated. Based on that, you can file accordingly in that particular patent office. Now, moving on to the next section of our talk, that is how to draft the patent application. So for that, I will go through the anatomy of the patent. That means I have shown some pictures of the published US patent over here, and so as to give you the idea what exactly the patent document when it is published by respective patent offices, how it looks like and what it comprises. So first is as you can see, there is United States patent, the patent defines. After that, the patent number is written on the right hand upper corner. So, and the date of patent as well. So in India, we follow 2 numbering systems. So first number you will get when you actually file the patent, and when the patent is at a prosecution stage, it is not yet granted by the patent office. And when the patent has been granted by the patent office, then you will get another number, the different number for your granted patent. So these 2 patent numbers for a same patent application you will receive. Yes, the patent also comprises of, when it is published, it also comprises of the title. As you can see, the RNA containing modified nucleosides and methods of use. While writing the title of your invention, when you are actually drafting the patent for your invention, the title should not be more than 15 words and it should be suggestive and not the descriptive. The main purpose is to, during, suppose if your competitor is also working on the same invention and if he want to search your patent, he should not get it very fast, so he has to do some he has to spend some time and then only he would be able to retrieve your patent. So the title should not be descriptive. Then the bibliographic page also comprises of the inventors. So inventors I have listed over here is Kathleen Carico and Drew Weissman. So these duo, so they have received the Nobel Prize in Medicine in 2023 for developing the messenger RNA based COVID-19 vaccine. So this is a very famous patent, and the inventors, the patent document, the bibliographic page lists the inventors as well, who all are inventors in this particular patent. The inventor, yeah. So the inventor basically,
Why are we being so
who can be the inventor? The someone who helped to conceive the specific features listed in at least one patent claim. So that person can be the inventor. Someone who has directly contributed to the creation of an invention through their own skill, ingenuity and labor. Generally, the colleagues, students, research assistants, technicians, mechanists, or their supervisors are not inventors unless they have made the inventive contribution. Inventor is always an individual. Then the patent also comprises of assignee. In US, they call it as an assignee. Assignee is the owner of the patent. In India, we use the term as applicant. But the scope is same for both the terms. The terminologies we are using by the different patent offices is different. So the assignee here in this particular patent is trustees of University of Pennsylvania. So this is a university who owns this particular patent. Applicant holds the right for that patent, and applicant decides whether to sell that particular patent, whether to collaborate with any industry. Ideally the applicant should pay the prosecution and maintenance fees for that particular patent as well. The patent also comprises of the application number and if the PCT is filed and the date of filing of the PCT. Then who can be the applicant? Applicant can be individual or entity. Any individual or entity can file the patent as an applicant, either alone or jointly. Organization, when there is an employee-employer relationship, employer is generally the applicant for that particular patent. It can also change at a later date when the patent assignment is done. And the applicant has all the rights to exploit the invention commercially, and it has given that person all the rights to deal with the patent. The Form 1 in our Indian Patent Act, when you file the Indian patent application, the Form 1 wherein the inventors are assigning their rights to the applicant with their signatures. So that is called as assignment of their inventor's right to the applicant, and they are okay that they are assigning their rights to the applicant, and the applicant can mention his name on the patent. So yes, after that the abstract, it should not be more than 150 words, and it should briefly describe what the invention is about and what exactly the different components of the inventions, etc. Then field of invention, the patent document also comprises of the field of invention. Field of invention, it should be brief and 1 or 2 sentences you should write. It is used by the patent office to determine the examiner to be assigned to and to classify the patent application. There are examiners at the patent office for particular technical domain. So depending upon your field of invention of your patent, the patent application will be assigned to that particular examiner. Then background of invention. In the background of invention, you have to write the story, how you come up with this invention, right? Basically, you need to explain what are the technologies available currently for this particular problem, and bring out the problems, issues or lacuna in those technologies, and how your invention is going to solve those particular problems. So this is a discussion that you should write in the background of invention. Then detailed description of the invention. Here you need to describe your invention and the different components, embodiments very clearly. You have to provide the illustrative examples therein, the experimental details. Then what is not described cannot be claimed. So you have to describe very clearly. You cannot write a claim the claim which doesn't have any support in the complete specification. Those claims are not at all allowed at the patent office. Last part, when we consider drafting the patent application, is claims. So claims define the scope or the border of the invention. So this is actually the legal part of the invention. It protects the inventor from the infringers, and these are the enforceable part of the invention. So if you can note the language is legal. The specific language is used to write the claims. The claims are two types, the independent claims and dependent claims. The first claim is always an independent claim, and the dependent claims define the further embodiments and components based, which are based on the first claim, the independent claim. Yes, so that was about what are different components of that you should consider while drafting the patent application. Now, once the patent is drafted, what is the next step? That the step-by-step guide how to file the patent application. Then you need to keep the documentation with you, like keep dated notes, drawings, prototypes, development timelines with you. Conduct the patent search or the prior art search. Identify the closest prior art and establish the novelty, inventive step and industrial applicability of your invention while drafting the patent application. Then decide the type of patent that you want to file. Either you want to file the provisional specification or complete specification. So what exactly the provisional specification or complete specification is? Provisional specification is generally filed to establish the earliest priority date, because the first filing date is called as priority date. In most of the countries, first to file system is applicable. So suppose if two inventors are working on the same invention, the inventor who goes first and files the provisional specification, he will get patent. So it is always advisable to file the provisional when you have not yet ready with the experimental details, etc. Then when the invention is only at the conceptual stage, very important document to establish the earliest ownership of the invention. You have a liberty to develop your invention further. Within 12 months time, you have to file the complete specification. It should be adequately simplified and it must contain at least one claim. And it should be submitted within 1 year. It is not always that you have to first file provisional and then file the complete specification. If your invention is ready, you can directly file the complete specification as well. Then, yes, when you file the complete specification, you have to write at least one claim along with the drawings and detailed description of your invention. There are two methods how you can file the patent at the patent office, Indian Patent Office. You can either file by e-filing mode or by physical mode. So by filing the patent application by e-filing mode, you have to visit the ipindia.gov.in. This is a patent office website, wherein you can, if you can click on the patents tab, then e-services tab appears, and after that the comprehensive e-filing services. So this particular tab appears. You need to click on that tab, and then the right hand side image will appear. So there, e-filing of patent applications. So there you need to log in. You need to log in the username, password and a captcha, etc. If you don't have account, e-filing account, you need to create the e-filing account along with either e-signature or digital signature. So you need to create that account, and once you are created with the e-filing account, then this particular window comes like application for grant of patent form 1. You need to enter the details over there, like number of pages, who is the inventor, applicant detail, addresses, phone numbers, email IDs. Then once you save this form, it will go into the drafted form section, and from there you need to upload the different parts like the drawings, complete specification and the forms, relevant forms with respect to that particular patent application in PDF format. After that, you need to sign each and every PDF, and then you can make the payment by online mode, either by credit cards or online payment or UPI payment. All those things are acceptable by the patent office. Once you make the payment, then receipt will generate, and that receipt tells you the application number as well as date of filing. So that was about e-filing. When you want to physically file the patent, you can actually go to the patent office and submit the physical copies, or else you can post those copies along with the DD, demand draft of respective amount to the patent office. So this is a typical patent prosecution timeline. When you file the provisional specification at the first instance, that is referred to as your first filing date or priority date. After that, complete specification filing you have to do within 12 months. If you don't do that, your provisional specification will be abandoned by the patent office. Then within 18 months from the first filing date, your application will be published by the patent office in their journal. Patent office publishes their journal on each Friday. You can have a look at those journals at their website ipindia.gov.in. Within these 12 months, you can also file the PCT application. So PCT application is a patent cooperation treaty. Around 158 member this treaty has around 158 member countries all over the world. This is a one window filing service wherein you can file only one application in one language, either to the International Bureau or to the Indian Patent Office. And this PCT application you have to file within 12 months from the first filing date or from the date of provisional filing. After that, you will the International Bureau, the WIPO, World Intellectual Property Organization, will publish your patent application. That is called as international publication, and they will also issue the search report. So please note that patent is a territorial right, and there is no concept of world patent or international patent kind of thing. So there are different filing systems. Either you can file in different countries with convention application or PCT application. So if you go by convention application, suppose if you want to file your patent in US, you have to file patent in US within 12 months from the first filing date. As an Indian citizen or Indian entity, you have to file your patent first in India and then you can go to the different countries within these 12 months. There are some exceptions as well, but let us not discuss those exceptions at this stage. Then the second route is PCT application. So you have to take the decision whether you want to file the patent application outside India. You have to take the decision within the first 12 months only. Okay. Then you can expedite the publication. 18 months is the timeline for, minimum 18 months is the timeline for automatic publication. You can expedite this publication by paying extra fees to the patent office. Within 31 months, you have to file the request for examination. Again, you can file the normal request for examination or you can expedite this procedure. This is mandatory fee that is applicable for filing the request for examination. Once you file the request for examination, patent office will examine your patent based on the novelty, inventive step, industrial applicability criteria, and they will issue you the first examination report. They will cite some prior arts therein, and you need to submit the response to that first examination report within 6 months. This examination report also comprises of some formal requirements, some fees related issues, or some exclusivity criteria if your invention falls under the section 3 and 4. They also cite those objections in the first examination report. You have to respond to that first examination report within 6 months. Once you are complied with the objection, very few times, like once you submit the response to the FER, the patent will be directly granted. Most of the times hearing will be there, so you have to appear for the hearing. Nowadays you can appear for the hearing by virtual video conferencing as well. And once all the objections have been removed by the examiner, your patent will be granted by the patent office, and if not, then re-examination and issuance of further objections will be there by the patent office. So this is a typical flowchart of the timeline. So I'll just skip this. Yeah, so applicable statutory fees for e-filing and for physical filing. For e-filing, patent office provides 10% fee reduction as compared to physical filing. There are two criteria. So first criteria is for natural person or individual as an applicant, startups as an applicant, SME as an applicant, or educational institutions as an applicant, or the other criteria is for other like big companies or research and development institutions, etc. For if the natural person or a startup is filing a patent by e-filing mode, then the fees applicable is 1600 only, and for others the fees applicable is 8000 only. I am going to read the fees for e-filing only, and I will not read the fees applicable for the physical filing. For each sheet, in addition to 30, rupees 160 is applicable for the first criteria, and for others 800 rupees is applicable. For each claim, in addition to 10, we have to pay extra. Request for publication, that is optional, as I have already mentioned. The patent office will automatically publish the patent application after 18 months. You can expedite this by paying 2,500 or 12,500 as per your category. And request for examination, that is mandatory. You have to file the request for examination within 31 months from the first filing date. For first category like natural person, startup, SME or educational institution, 4,000 is the fee applicable, and for others 20,000 is the fee applicable. There are other fees also involved during prosecution. So those fees you can have a look at IP India website in forms and fees section or the first schedule section. Yes, so I have given one example of patent drafting over here. So this is for illustrative purpose only. So the invention is related to the smart water bottle reminder. So what will be the title of my invention? Like I can write the title as smart water bottle with hydration reminder system. As I have already mentioned, it should clearly identify the product and does not use the promotional word like the best, amazing. So these kind of promotional words or adjectives are, this is not a good practice to add these adjectives in the title. Then field of invention. I would write the field of invention for this particular invention is the present invention relates to portable drinking containers and more particularly to a smart water bottle incorporating a hydration reminder system for reminding users to consume water at predetermined intervals. Then I would write the background of invention. There exists a need for a water bottle that automatically reminds users to drink water. So here we need to write a story, the state problems in the prior art and how you are going to solve those problems, etc. After that, summary of the invention comes in. The summary of the invention should be aligned with the first claim generally. Here you need to define the different components of your invention like a reusable water bottle, timer circuit, LED light, small buzzer, push button to reset the timer, rechargeable battery, etc. And when 1 hour passes without the reset button being pressed, the LED flashes and the buzzer sounds. Drawings. This is the most important part of the invention in case of mechanical invention. When in case of biotechnology related invention, you have to provide the sequences, or in case of pharmaceutical invention, you have to provide the marker structures. The different requirement for the patent drafting depending upon the domain of your invention. So here you have to provide drawings related to overall bottle, the cap, the battery circuit, LED buzzer, etc., the block diagram. The drawings are for illustrative purpose and it will further specify your invention in detail. Then components and specific numerals assigned to them. So instead of writing the components, for example, the timer circuit, LED light, I would like to use some numerals specified to these particular components. For example, I will use 100 for bottle, 110 for cap and 120 for LED, etc. While writing detailed description, I will use those numerals. For example, the smart water bottle 100 includes a bottle body for storing water. The timer circuit 140 is positioned in the base of the bottle and powered by a rechargeable battery 150. The timer activates an LED indicator 120 and a buzzer 130 after a predetermined time interval. The user may press the rest button 160 after drinking water, thereby restarting the timer. So the detailed description describes each and every component, each and every embodiment of your invention, their interconnection, the working of your invention, everything. So in detail. Abstract, the smart water bottle is disclosed that includes a bottle body, timer circuit, rechargeable battery and LED, buzzer, reset button, etc. The timer monitors elapsed time after a user drinks water and activates the LED indicator and buzzer after predetermined interval to remind the user to drink water. So this kind of abstract you can write for your invention. And the claim, example claim I have written over here is the smart water bottle comprising a bottle body, a timer circuit, a rechargeable battery, LED indicator, buzzer, reset button, etc. Wherein the timer circuit activates the LED indicator and the buzzer after a predetermined time interval to remind the user to drink water. So these are some examples of how you can write different components of your patent application when you actually start drafting for your invention. So what all mistakes you can avoid? Public disclosure before filing. Don't disclose your invention to public before filing your patent application. Don't skip for the prior art. So you have to do the prior art search so as to check the novelty, inventive state and industrial applicability of your invention or the statutory requirement of your invention beforehand, before drafting and filing the patent application. Don't write the too narrow or too broad claim. Claims should define the scope of your invention and not beyond that and not below that. Waiting too long. Don't wait too long to file the, at least file the provisional specification first, because first to file system. Someone else may file first. Then filing provisional and doing nothing. You have to file the complete specification within 12 months, otherwise patent office will abandon the provisional specification. So please remember these timelines, like when you want to file the complete specification, when the publication is there, what is the deadline for filing request for examination. So all these timelines are calculated from the first filing date. So please remember all these things beforehand. Filing only in India, don't do this mistake because patents are territorial right. Filing separately in each country versus specific filing you can consider, and filing without market assessment. So that is also not a good practice. What can you do after filing a patent? If you file the provisional application first time, you must submit the full specification of your invention within 12 months of your patent application, otherwise it will be abandoned. Then track the prosecution of patent applications such as the publication, examination, responses. Missing a deadline can result in loss of right. Consider filing follow-on patent applications or any improvements so as then maintain the records of experimental results, design changes, laboratory notebooks. So these records can support the future patent applications and publications, commercialization, etc. If commercialization outside India is planned, then identify the target countries and consider filing in those countries. The filed patent can increase the credibility during discussions with investors and industry partners. So explore licensing or collaboration opportunities with industry partners. So that's all from my side. So maybe Mukta, we can switch over to the next session. That is related.
I think we'll now go to the question answer session.
Sure.
First of all, I think unfortunately we couldn't, there was some glitch with our Zoom account because of which we couldn't bring in everybody who had signed up. But whoever are here are welcome to ask us questions. I have tried to answer a few online which came during the talk. I'll try to take some more as well. But there are also questions which have come to us to the registration form, so I'll try to take those as well along with Archana. So maybe we can take as we go along, right? So feel free to type your questions in the chat box and I will try to take them in as we go along. Just the ones which had come in between. There was a question about, I'll just take it in no specific order, but Manish had asked a question about funding opportunities for independent innovators. How to commercialize a product which is granted, approach for getting prototype manufactured from industry. Now, some of these are not entirely within the scope of this talk, but let me just tell you that we have a mentoring session. We run these mentoring clinics which are free for all, and I put the links in the chat box. You're welcome to use those. This is something which I'm putting it again. Okay, so this is, you can sign up here and ask specific questions. There are funding opportunities available through certain programs. So one is you can, of course, build it into your grants that you write. So when you write a grant funded project, you can build a cost relating to IP into it. Another way to do that is that there are many state governments and MSME ministry, for example, which offers reimbursement for certain patents and so on and so forth if you approach them. So there are such programs which you can leverage. Many of these are not available necessarily for individual standalone innovators. So you have to check the eligibility criteria and then apply for those as well. The other two topics, commercialization, prototyping, are a little longer topics, so I will not take them up. Dr. Jaga's questions, I have answered a couple of them online about combinations of physical sensors and AI and so on. So typically you write them as claims which are of a nature of a system where you can include both of them, but still the novelty, non-obviousness, utility, and all those kind of rules will apply, but you can still write it as a system that you're claiming in your claims in your patent. Okay. I think there are a couple of these which I have already answered. So let me take a few while the new ones are coming up. Let me take up a few. There was a question about paid databases which I have also answered. So some of you might have already seen it. So there are all patent offices are obligated to put out their databases online free for searching. Okay, so you can find every country's database online, right? Now, and some countries, like some regions like European Patent Office, that it covers multiple countries. eSpaceNet database, plus Google Patents and so on also cover a lot of ground. So there's a lot of free softwares available which you can use to do your searches. Prior art searches with free databases are fine. There's nothing wrong with it. It is just that the paid ones make it a little more convenient, add features and so on and so forth. So if you don't have the resources to buy the paid database, it doesn't mean that you cannot do it. It is possible to do it free yourself if you wish to do it. Okay, so that's something which you can keep in mind. It's not a showstopper in any way. There's a question from Vinod Kumar. As an inventor, what details I need to be ready before reaching out to patent agents or lawyers? Drafting is done by whom? Okay, so as Archana pointed out, I mean, this session is actually a do-it-yourself primer. It was to essentially empower innovators and inventors to talk about some of these topics. We wanted to also make it clear that it is possible to draft and file on your own, and it's not that you cannot do it. But this area requires some expertise sometimes, and it's better in some cases to have the benefit of professionals. But if you can't afford it, it's not a showstopper. You can go and file on your own. In fact, many individual innovators file on their own around the world, and it's quite a tradition in many places. I think has Dr. Shiv joined the meeting here? So, Dr. Shiv, did you want to comment on anything? We would love to hear your perspective on the topic today, and if you want to speak about your views from the ANRF side, that would be welcome. Dr. Shiv, are you online? Can you unmute? Okay, maybe we'll continue with the questions, and they can, Dr. Shiv can comment at a suitable point. Let me just take up a few other questions, and then we can discuss it further. In the registration forms, there were several questions which were there were questions on: is it advisable to file a patent yourself or go through agents and so on and so forth? As I mentioned, this requires some amount of understanding of the patent law, and because of that, sometimes it's better to go via with attorneys and registered patent agents with the patent office. But that said, if you cannot do that, you can file it yourself. There are a lot of people who do it themselves as well. They're professional inventors who in the US have filed for many years their own patents. Okay. We have learned today about how to write and file patents, how to apply for a patent as a beginner. And the question was, is it tedious? Is it lengthy? How to do it faster? And so on. So the patent drafting process requires you to, first of all, understand what the patent law is doing, which is basically asking you to suggest what is right to write, what is your invention, and how it provides a solution to a given problem. So if you understand that, it's possible to articulate it quite clearly in a document which basically lists out the problem, proposes your solution, points out novel elements, and provides some data which you can use to defend why it is non-obvious. And then some examples of how it was implemented. The tricky part is often the claims section, which is the legal part of the patent, where you have to draft it suitably in order to cover adequate ground in terms of coverage. And that is where you have to use your words carefully in the way you write claims or where you structure it. And that is a longer discussion, so we won't have time to do that. If you want to do it faster, it's good idea to break it down into these parts which I mentioned, work on it, and then refine it as you go along. It's also a good idea to look at other patents which have been filed by people on similar topics and see how they have drafted it, what the claims look like, and so on and so forth, and borrow on the structure of the language that people have used. For example, something may have been called a container, or something would have been called a system, or something would have been called a device. You may want to use language of that kind in order to capture your invention. Any other tricks for faster?
Faster drafting, as such, there are no tricks. So I would suggest don't hurry up in drafting the patent applications. Take your time and revise the patent drafts whenever you draft the patent. So at least 2 times you have to read your patent draft, and then you are very sure that the scope of invention is covered in the claims, then maybe you can go ahead with the filing. For expediting processes at the patent office, so I have mentioned that expedited request for examination and publication. So these things are available.
Yeah. So there's a question from Keshav Kumar on what's the difference between patent publication and patent grant. Is the patent grant recognized globally? How does my patent secure my invention globally? I think you explained some of it. Can you repeat that a little?
So the patent publication, so 2 types of publications are there when the patent you file. So first is automatic publication. When you file the patent, it will happen after 18 months from the filing date. And another publication is after patent grant. So you will receive the patent grant once your invention satisfy all the novelty inventive step and industrial applicability criteria, and it has to follow the steps like the examination, responses, hearing, etc. So that is a difference between publication and grant. This patent grant is recognized globally. See, there is no concept of world patent. You have to file separately in different countries so as to secure your rights in those countries. And once you get the grant, it is not always that if you receive the grant in India, you will also receive the grant in US or in Europe or in Japan. So you have to prosecute different patent applications over there, and you have to follow their IP laws so as to get the patent grant. So I think
So just if I can add one thing, which is unlike in manuscripts, publication, scientific publications, scholarly work, when you publish it, the job is done. Here, that is not the case. Okay. When it gets published, it just becomes public. Okay. After that, the grant is when you actually know what is the scope of the claims that the examiner has allowed you. Okay. But that said, the priority date is very important. That means the first date of filing is very important, because anybody filing after that, your patent application which was filed before becomes prior art for the other one. So the priority date is extremely important. The other thing to note is that if somebody copies your patent, okay, and there's a lawsuit and there's an infringement suit where let's say the inventor sues this person saying that you have copied my patent, the damages apply from the date that the patent was published. Okay, so the publication date is important for that purpose. Okay, so that's the reason why it's important. As Archana has said, there's no such thing as a global patent. There is a patent, there's an application called the PCT application, which allows you to make sure that so many countries will recognize your date, priority date, okay, and allow you some time to file in those countries, right? that is what is called the PCT application. It's you'll find that especially on the WIPO database, World Intellectual Property Organization, but it doesn't give you rights in those countries unless you go and file in those countries. Okay. So Archana had spoken about general cost of filing patent.
So the general cost from filing to up to 20 years, it will cost you around 80 to 90,000, and I am talking about the statutory cost that you need to pay to the patent office. So the attorney fees, if you hire the attorney, that varies from person to person. So that I have not included over there. But that 80 to 90,000, you don't need to pay at once. So there are stage wise you have to make the payments to the people.
Yeah. So for example, if you file once and then over the period of the year you realize that this is not a good idea and I should withdraw it, you can withdraw it, right? And the remaining cost doesn't you don't have to pay that, right? If you think you want to continue, or you have collected new data, or you found a partner who's willing to say license it from you, then that cost can then be borne by the licensee also. Right, so you can stage your costs, and as an individual or a individual inventor or an inventor with a very low budget, we would advise that people should stage their costs if they are bothered by what kind of cost they will incur in filing those patents. The government has made provisions by which many categories received highly discounted costs, so you can benefit from that as well. Startups have some benefits, academic research organizations, the government have certain benefits and so on, and these are some things which you can leverage as well. Okay. Jitendra Kumar has a question. Without help of a patent agent, patent application can be granted to applicant. If not, in which stage patent agent plays a role? See, patent agent is a person who understands the patent law adequately and can present your invention to the patent examiners in a form that is aligned with the patent law. So in the sense, they have to basically defend saying that this is within the patent law. That's why there's a patent agent. Okay. Now that is not a necessity to have. Okay, the inventor can defend it themselves if they're capable of doing that. So it is not an essential item. It is something which is desirable but not necessary. Okay, so you can you have to take a call based on that in terms of whether you want to engage a patent attorney or an agent to write up your patents and so on and so forth. Right?
In addition to that, he is asking like what is the role? So the role, see, the patent agent is the agent between the inventor or the applicant and the patent office. So he can represent on behalf of you to the patent office in case of hearings, as well as he can draft and file the patent applications, and the responses of the prosecution. He can actively take part, and he can assist you in those particulars. So that is typically the role of a patent agent.
Yeah. So Dr. Gibson had a question. May I know what's the usual average timeline required for patent filing to grant, right? So I think Archana had put down how the patent filing process works. So a simple version is you first file a provisional, say that's day 0, okay? So at about 12 months time, you're basically filing your, that's the last date to file your complete specifications, okay? At that time, if you want to use the PCT or the convention approach, you have to file a separate application for that, okay? A convention application or a PCT application if you want to enter other countries. The complete specifications then get published at around 18 months timeline, right? And after that, when the examiner will take it up according to their queue, but if you want to expedite it, you can request an expedited review, and in which case that's for a fee, and then you can get a grant after all the arguments are over, right? Now this grant process can take time sometimes, depending on different offices have different queues. In India, the timelines can be long. It has improved considerably in the last several years. But that said, I just wanted to point out that the grant date is not necessarily the most pressing and most important date over there. Okay, it's a priority date that you should think about. You can go and talk to commercial partners even before a grant is received. Okay, in certain domains, the grant, an early grant is more useful than in certain other domains, but it doesn't prevent you from commercial discussions. In fact, it doesn't even prevent you from a licensing agreement. You can license a patent even before it is granted, but of course, you know, if it doesn't get granted, you might lose some of the some of the terms will be structured in the license agreement such that, you know, you lose something if it doesn't get granted, right? So please keep that in mind. I think, right? Okay. PN Jyoti has a question. Kindly give information about schemes that are available to assist financially for filing a patent. Okay. So for filing a patent, as I told you, first of all, that the government has reduced costs for certain categories. So first thing is, please leverage those, right? Use those categories, whichever categories you can leverage out of them. And those numbers are fairly small, okay? So I don't think that should be a big hurdle. The second thing I told you is that if you're writing a grant, research grant, build some cost for IP into it, right? And there are many research grants which will allow you to say that I'm going to keep, say, 1 lakh, 2 lakhs for this particular patent filing and prosecution. So use that, right? The third approach is that there are government programs which will reimburse certain costs. For example, MSME Ministry has such a program. There's a program from, say, state governments like Maharashtra state government, which will reimburse certain costs for related to patents. So you can use those as well. So from time to time, there have also been other programs. For example, BIRAC has a nice program called PATH, which allows where you can apply and they would consider you for some financial support for those patents, but through their empaneled attorney firms and so on and so forth, which is possible as well. Right now, ICMR has announced a program where they will help you through the Patent Mitra program with the filing and prosecution and the costs associated with that. Okay, so depending on your domain, you'll need to seek those opportunities out. But of course, before all of that, please check that your university doesn't already have an IP cell which can fund some of your patents costs and so on and so forth. Okay, the IP cells have a small budget usually for some of these filings, and right now many universities are filing patents and they should be able to cover those costs or build it into some project financing that they also might be doing for you if you're an academic associated with that university. I think that covers that question as well. Any more questions, please keep putting on the chat box. I'll take a few more from the registration. There was a question, does an invention need to be highly novel or highly useful? And what is the level of novelty usefulness is required for filing a patent? Okay. And the second question, which I'll let you take, Archana, is how are new ideas cross-checked against existing patents? How are similarities assessed? And what role do geographical and national boundaries play? Okay. So maybe you can start with the first one. How are new ideas checked?
So as I have mentioned, the prior arts, there are some databases available. So the free databases, you have to check what all the prior arts available which are very relevant to your invention. Just put the keywords related to your invention and check. So non-patent literature as well as the patent literature, and based on those prior arts, you can check whether your invention is really has novelty, inventive or industrial applicability. So that is just related to the prior art searches.
Yeah. So as mentioned earlier, the concept of novelty is a global concept. Okay. If anybody has anticipated your idea, exactly similar idea anywhere in the world in any kind of public disclosure, then that can be prior art and it can be grounds on which your patent can be denied. Okay. So there's no boundary there as far as assessing novelty is concerned. right? So being novel in India is not good enough. You have to be globally novel, right? The second thing is how highly novel or not. So I should make it very clear that most inventions are not for very disruptive ideas. They are for incremental ideas. Okay, so it's not like the whole world changed because of that. It could just be that something improved on an existing product. So don't stop yourself from filing a patent because you have set a goal for yourself that it has to be a highly disruptive idea. That's not the way it works. Most patents are for very incremental ideas, and most that get licensed also will be for incremental ideas. Okay, so please file for those which you think are useful, which somebody would be interested in, which you think needs further development. Those are the ones you can file for also. It doesn't have to be highly novel or highly useful. It just needs to meet the requirement of the law. Okay, as long as it is novel as per the law, you will get a patent. Okay, I think there are a few more questions which have come, so let me take that. If my patent is published, should I compulsorily go for patent grant, or can I stop with patent publication? So Keshav Kumar's question, see, the patent, if it is published, it's only a disclosure. It is not a right given to you by the government, right? So unless you get a grant eventually, or at least work towards it, no commercial party is going to be interested in licensing from you. Okay, so, or you won't be able to enforce it against anybody who copies your ideas, and you want to ensure that nobody is copying your idea or using it without your permission, right? So grant is important. Okay, so you have to take it to grant. Just publishing it is not adequate. The whole purpose here is to create property, right? The property gets created at the point of grant. Okay, remember that government is giving you a property at the point when your patent grant is given to you, right? Okay, there is a feedback form which has been put online. Request attendees to kindly help fill that up so that we can improve it in the future. This kind of an event, so that it's more useful to many more people. Okay, okay. So there were some questions which were relating to specific domains, and I'm going to quickly request Archana to address them. Right. One question was relating to Section 3I. Right, and question was relating to antimicrobial compositions intended for human use. Right, does 3I apply to such a case because it's an antimicrobial composition for use? 3I, just to remind people, is one of the provisions in the Indian patent law which basically indicates topics which cannot be patented or cannot be allowed. 3I talks about any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or any other treatment of human beings, or any process for similar treatment of animals to render them free or of disease, or to increase their economic value or that of their products. The operative word is treatment. Okay, here, yeah, go ahead.
So this thing is patentable. The antimicrobial formulation is patentable. So while drafting the patent application, we have to be careful that we should write a claim for the formulation and not for the method of treatment, and how this particular formulation is useful, and what exactly the first step, second step, third step, and how if you want to add something in it, suppose the water or any other component. So these kind of steps or these kind of claims are not allowed. But the claims related to formulations are definitely allowed by the patent office. And while drafting the claims for the formulation, it is to be noted that it should be the synergistic composition, and it should not be just merely the addition of the components. So that also you have.
So there's another question on how can patents be filed for firmware, software development, algorithms? How can I patent an AI app before launching it in the market? You want to add some points?
See, as per Section 3K, that is again related to the computer related or the pure algorithms or the business methods. So these type of inventions are not patentable
in India.
In India, yeah. So if it is related to only algorithm, that is a sequence of steps. So those type of claims or the inventions are not allowed. But if you are developing if it is in if it is in combination with any hardware, then you can file the patent for the system. And also, if the mobile app is doing, or if the mobile app is achieving the technical enhancement. So the word technical enhancement is very, very important over here. So Patent Office has published the computer related invention guidelines recently in 2025. So please look at those guidelines. So they have mentioned over there like what type of claims are allowed and what type of claims are not allowed as per the section PK. So please refer to those. And that is possible, and it depends on invention to invention. So yes, sir. So I will give them all these things as references when we share the slides.
Yeah. Okay. There's also a question about herbal product formulations, another category, right? Can they be patented?
Yes, the herbal product composition is also patented. However, it should not fall under the traditional knowledge, because traditional knowledge related inventions are not at all patentable as per our section 3 of Indian Patent Act. And we should take care of, it should not be just the addition of the components. Okay, it should be the synergistic formulation in specific range. If you add the component A, B, C, D so as to get the desired result, then only these type of formulations or compositions are allowed, or these type of inventions you can file a patent.
Yeah, so that's section 3P, okay, of the Patent Act.
Yes.
Okay, now there are questions on who is responsible for filing, who bears the cost, who owns it. For employees and IT services companies, how can one distinguish personal inventions from company IP? Can an employee independently register an idea developed while working? So let me take this up. So first of all, you have to understand what agreements you have signed as an individual with other partners before you file for a patent. So for example, if you're an employee of a company, you would have signed an employee agreement, right? And the employee agreement will have certain clauses which relate to intellectual property. So for example, most private companies would say that any IP that is created in the course of the work will belong to the company. In India, you'll see this very commonly. I mean, this is the norm, right? In which case you have signed up to a clause which says that the employee will inform the employer about the creation of intellectual property or an idea, and the company will file the application, right? So that's the deal there, and which of course you should follow. But there are sometimes situations where our companies and organizations will outline the scope of what is covered under those terms. For example, it might say in the US, it's very common to say that if company resources or organizational resources were used for that activity, then it belongs to the company. But these wordings have to be studied to understand what is the scope of all the ideas that you are generating. There might also be a situation where you go to, as an employee, you go to a company and the company says, we are not interested in filing. And they may give you a right to go ahead and file it yourself if you want. That's called a waiver. And that also is possible. It can happen and you can explore that as well. Usually, it's the owner of the patent, whoever is going to file as an applicant, who bears the cost of filing the patent. They are usually the people responsible for filing. So the administrative responsibilities usually rest with the applicant or the assignee, which is the owner basically of the patent, not necessarily the inventors. But there may be individual inventors who are also, besides being inventors, are also assignees or applicants, in which case they will have the responsibility of filing, prosecuting, paying for the costs of maintenance and so on and so forth as well. Okay. Archana has explained how to identify the inventive concept. A little bit, there were questions also on claim design, best practices, claims and synergistic interactions and so on and so forth. So patent claims are usually written up in order in such a way that you are covering the scope of the invention such that it's like a boundary wall that you're putting around your idea, so that People, unauthorized people, do not misuse that idea without your permission. Okay, so you have to decide what that boundary wall is, and assuming that the examiner will have arguments on how to reduce the size of the boundary wall, the typical strategy is to construct, is to propose boundary walls of different sizes, right? Essentially, these are structured as independent claims or dependent claims, and examiner agrees on one which they think is appropriate, and that is the scope of the boundary wall that you get, right? And you can protect different kinds of things. You can do processes, you can do products, you can do systems, you can do various different compositions and so on and so forth as well. Okay, so those claims require a lot more longer conversation. You may not be able to take up here, but if you need to discuss some of these, you can use our mentoring clinics, which we have, which are free under the ANRF Plus program, which you can definitely use. I'll put it again in the chat box. Okay. So Jaydeep has a question online. Out of the whole process, organic chemistry of API, last step is only the novel process. Is this process eligible for a process patent? If yes, then what is your suggestion? Shall we go with the process patent or trade secret? Okay, so this question of trade secret and process patent I will take up, but let's first talk about whether it's patentable or not, right? So let's say there is a process which has A, B, C, D, E, F steps, process steps, and what you're saying is the last step is novel. So you basically have to evaluate that last step and see that beyond novelty, is it also not obvious, okay, or it is inventive. That's what you have to prove. Basically, if you have come up with a new way of doing it which nobody else anticipated and is not an obvious extension of whatever was done in the past, then it could be treated as novel, and you will probably get a patent for it as well, a process claim with a process claim as well. So just to explain, suppose let's say that somebody had done a catalyst C and you have a alternative catalyst which has no similarity to what has been done and cannot be treated as an extrapolation. It can be a novel idea, and you will get a process patent for it. Now the question is, should it be filed or not as a process patent, right? Or should it be kept a trade secret? Now this is a business question where you have to ask the question, is it more advantageous for you to make it public through disclosure, or is it better to keep it as a secret in your company? Now this question requires you to also think about, if it is made public and somebody copies it, is it enforceable or not? Okay, that means, can you first of all detect infringement? Can you find somebody? Can you say that this person copied it? If you find it, is it enforceable or not? Right? This is the question. Now in India these days, enforceability has improved considerably. So if you detect infringement, it will be possible to enforce it through the law. It takes time, but it is possible. But the first problem you'll have is detection. How do you know that your process was used by your competitor or somebody who is copying it, right? So this is something which is a business decision. You have to take a call yourself. But there are some other general principles which you can follow, which you have to zoom in on what is novel, and only look at patenting that, and not necessarily trying to cover everything, every part of your know-how, right? So there may be some things you can keep as trade secret, something you can patent. So this is a strategic business decision which you need to take based on detection, ability to detect, enforceability, how easy or difficult it would be to replicate, and so on and so forth. Okay. Okay, I think you have answered that question as well. I have a couple more questions, and we'll close within next 3 minutes. Okay. There is a question which has to do with there's a question about careers, and I just wanted to just bring that up. There are people who are interested in building careers in patent law and so on and so forth. And there are also people who want to start drafting their own patents. So the question is about what is the roadmap for a career in patent administration and patent science. So one is, of course, I just lay it out and then you can address it. There are careers in patent agents. There are careers as patent examiners. There are careers as people who do patent analytics. That means analysis of a lot of data and coming up with reports and which can be used for strategy, right? And then there are careers which might have to do with litigating it, enforcing it, and so on and so forth, which typically is slightly different than some of this as well. And there are some more, but let me just stop here and ask Archana that how do people, what are the career paths for people taking up any of these?
Yeah, so you can explore the WIPO website, that is World Intellectual Property Organization. So they have various free courses as well as some paid courses. If you want to start your career in this IP field, of course, as Sir said, that patent agent examination is there, and I think the registration is still on up to 31st August. So you can explore the patent office website. You can fill up the registration form and you can appear for that exam. That exam is conducted by the patent office each year. For patent examiners also, patent office conducts the exam, and wherein the technical knowledge is required in that particular domain. That is not yet announced by the patent office. Also, in case of patent analytics, UDIP in Pune, they provide the patent informatics course, certificate course is also available over there. So these types of career options are available if you want to do career in IT, in patent.
So I think with that we have covered most of the things.
Yes.
So on that note, we will close. I thank you to all of you for joining in. If anybody from ANRF would like to speak, please let us know.
Dr. Shiv, if you are available to speak, you can
I
unmute
think
yourself.
he's probably busy. Okay, so the feedback forms are again online. Kindly please give your feedback so that we can use it to improve our programs in the future as well. And our team has also put the link online. So I think on that note, we will close now. Yeah, thank you very much. And please send us your questions, and we will put this out online as a YouTube video, as well as we'll put out some of these slides through our website, which will be available. So my apologies to those who could not join in the Zoom call because of the glitch, but we'll definitely make sure the YouTube videos are available to you.
So on that note, I thank the speakers, Dr. Premnath and my colleague Archana, for this session, and we will keep everyone informed, those who have joined and those who have registered for this session, about the upcoming talks in this webinar series. So please stay in touch with us. Thank you once again.
Thank you.
Thank you.